This is the Baker Act training, Minors, Module 1. In this module, I'll discuss the psychosocial stages of child development, provide an overview of the Baker Act, and identify special admissions provisions under the Baker Act that pertain to minors.
I can't even understand you. You're crying so much. When you're done crying, you come up and ask me what you want nicely.
Mommy, I want it.
What do you want, Andrew?
Tomorrow night we have a van ride, all right? And if you're good and if you feel better, maybe we'll take you out on the van ride,
Okay.
all right?
You're gonna stay back with me, Brian. You're not gonna go to the canteen.
Oh,
You don't have any money, Brian.
Brian?
Settle down, Brian. Come on.
Now settle down, that's it, you breathe, that's it.
Come on, lay down on your bed.
All right, come on. Brian, no, you're not gonna trip this dude. Come on.
Well, Brian, you want us to take it out of your room?
Come on, I want you to lay down. Come on. I want you to...
Yeah, you're getting
Brian,
yourself.
Brian, you're getting all worked up. Come on. Come on.
All children are oppositional from time to time, particularly when they're tired, hungry, stressed, or upset. They may argue, talk back, disobey, and defy parents, teachers, and other adults. Oppositional behavior is often a normal part of development for 2 to 3-year-olds and early adolescent. However, openly uncooperative and hostile behavior becomes a serious concern when it is so frequent and consistent that it stands out when compared with other children of the same age and developmental level, and when it affects the child's social, family, and academic life. To understand abnormal behavior, one should have a frame of reference as to what is to be expected or standard at different ages or stages of growth. Thus, we'll begin this course with a brief overview of child development. From Erikson's psychosocial perspective, the emphasis is on how relationships we have with others influence the development of our personality. It focuses on different stages of life and how these relationships impact growth. Ego identity refers to interactions with others and how we become more conscious of ourselves and our surroundings as we grow. In terms of ego strength, as an individual develops, they accomplish tasks and that strengthens that trait and they become more competent in that area. Within each stage, an individual must master skills or overcome conflicts or crisis. The potential for growth is high, and so is the potential for failure at each stage. Conflict prepares us for the next stage, and when successfully managed, allows us to move on and up to the next stage.
Stage 1 of Erikson's psychosocial theory deals with the age between birth and a year and a half. During this stage, the major conflict is trust versus mistrust. At this stage, the child is completely dependent on their caregivers. The child learns trust by being given the necessary means to both live physically and emotionally.
However, if we fail to experience this trust and our needs are constantly not met, then we may end up with a feeling of worthlessness and mistrust others.
Stage 2 of Erikson's psychosocial theory deals with children ages 1.5 to 3. The major conflict during this stage is autonomy versus shame. This stage, children are becoming more independent and learning things on their own. It is in the parents' reactions to their children's actions that develop this part of their personalities. The parents need to be patient and encouraging in order for their child to develop properly in this stage.
During this stage, a child learns to master finer motor development skills like walking, talking, and feeding themselves and using the toilet. A toddler with a sense of shame and doubt will be more withdrawn. They'll appear to lack confidence, and they tend not to venture too far into areas that they have not been before.
Stage 3 of Erikson's theory deals with ages 3 to 6. The major conflict in this stage is initiative versus guilt. This is considered the play age for children, where their imaginations grow. They begin to mimic and mirror what they see. They also learn morality. When they do something wrong, they can now expect a punishment. This is how they are taught guilt.
A preschooler with a sense of initiative will tend to complete tasks that they start. For example, if they start to draw a picture, they'll keep drawing until they finish it, whereas a preschooler with a sense of guilt will tend not to seek challenges, and they tend to hold back expressing who they are and what they would like to do.
Stage 4 of Erikson's theory deals with ages 6 to 12. The major conflict of this stage is industry versus inferiority. This is the age where children spend more time with their peers and teachers than with their parents. This causes them to have a much bigger influence on them. This is considered their entrance to life, where they are becoming very independent. They become inferior in this stage if they do not succeed socially.
If a child experiences unresolved feelings of inadequacy or inferiority among their peers, they can have serious problems of competence and self-esteem. Children with a sense of inferiority tend to display the opposite types of behavior from one who has that industry or competence. For example, they maybe act uninterested in their schoolwork or tasks that they're given because they feel that they're not good enough to compete with and complete those tasks successfully.
Stage 5 of Erikson's theory deals with the ages 12 to 18. The major conflict of this stage is identity versus role confusion. In this stage, people pull away from the influence of their peers and teachers and start determining their own identities. This is when people go through puberty, so there is a large change at this point in their lives as well.
An adolescent with a strong sense of identity will feel as though they know where they're going in life, or at least what it is that they would like to do when they're older. Unfortunately, many children or adolescents at this period are withdrawn from responsibilities, and if they're unsuccessful in navigating this stage, they'll experience role confusion and upheaval.
Stage 6 deals with ages 18 to 35. The major conflict of this stage is intimacy versus isolation. During this time, a person begins to settle and want to start a family. Oftentimes, failing to find a romantic partner at this stage causes people to have isolation from others.
An adult who's capable of intimacy will tend to form close friendships and possible romantic relationships, while an adult with a sense of isolation finds it difficult to form relationships with others and is unable to understand what others are thinking or feeling. As a result, they tend to spend most of their time alone with no friends. Let's begin with the general Baker Act process for admission and treatment of patients. The special provisions for minors will be identified and highlighted throughout the course. As a frame of reference, a minor is any person under 18 years of age who has not been married and has not had a court remove the, quote, disability of non-age. However, most references in the Baker Act are to persons under the age of 18. Therefore, one must consider a person aged 0 to 17 as a minor for the purposes of the Baker Act. The Baker Act statutes further define minor as adolescent, a person who is at least 13 years of age but under 18 years of age, and child as a person from birth until the child's 13th birthday. Review these other definitions for additional clarification, and then we'll start with the Baker Act law. A person can be on voluntary or involuntary status under the Baker Act. However, to be on voluntary status, a person must not only be willing to consent, but competent to consent to admission and to treatment. If a person is incompetent to consent to treatment, then they can't be held under the voluntary provisions of the law. Incompetent to consent to treatment means that a person's judgment is so affected by their mental illness that the person lacks the capacity to make a well-reasoned, willful, and knowing decision concerning their medical or mental health treatment. A person on voluntary status is presumed to be able to exercise all of their rights under the law, including that of consenting or refusing consent to admission and or to treatment. The Baker Act encourages the voluntary admission of persons for psychiatric care, but only when they're able to understand the decision and its consequences and are able to fully exercise their rights for themselves. With few exceptions, the Baker Act makes no distinction between the treatment rights of adults and minors. The exceptions are right to consent to treatment and right to consent to voluntary admission. A person 17 years of age or younger may voluntarily enter a facility for observation, diagnosis, or treatment, but only after that minor agrees to admission and the natural or legal guardian requests admission and a judicial hearing verifies the voluntariness of the minor's consent. The disability of non-age of minors, Florida Statute 743, states that a person under the age of 18 is considered legally incompetent due to presumed immaturity of judgment. I think Erikson's stages of psychosocial development confirm this. Generally, persons under the age of 18 cannot consent to a voluntary admission because minors are to be presumed legally incompetent due to age or presumed immaturity of judgment. Thus, the need for the additional safeguard of the parent or guardian consent and the judicial hearing for this voluntary admission. I will discuss some of the exceptions to this statute in Module 2. Form CF-MH3097, Application for Voluntary Admission-Minors, may be used to document a guardian's application for admission of a minor to a receiving facility. To be admitted under voluntary status, the individual must show evidence of mental illness, be competent to provide express and informed consent, and be suitable for treatment. Such a person 18 years of age or older may be admitted to the facility at that point. Each person entering a facility, regardless of age, must be asked to give informed and expressed consent for admission and treatment. If the person is a minor, express and informed consent for admission and treatment must also be requested from the person's guardian. Express and informed consent for admission and treatment of a person under the age of 18 is required for the minor's guardian, from the minor's guardian. The definition of mental illness under the Baker Act 394.455, subsection 18 of the Florida Statutes reads, an impairment of the mental or emotional processes that exercise conscious control of one's actions or of the ability to perceive or understand reality, which impairment substantially interferes with the person's ability to meet the ordinary demands of living. For the purposes of this section, the term does not include a developmental disability as defined in Chapter 393, or intoxication, or conditions manifest only by antisocial behavior or substance abuse impairment. It's important that you understand and know that definition of mental illness, because to be Baker acted, Both the criteria that I just read need to be in place. The clinical component, meaning an impairment of mental or emotional processes that exercise conscious control of one's actions or ability to perceive or understand reality, and that functional component, meaning it substantially interferes with a person's ability to meet the ordinary demands of living. There are some individuals whose mental illnesses are so severe and last so long and cause such dysfunction in their lives that nothing short of guardianship will do in order to provide the person the protection of the court. While it's difficult and can be somewhat expensive to obtain a guardianship, often petitions are filed with the court for, quote, lack of capacity, unquote, as a result of DCF protective investigations. If there's a conflict between the rights of the guardian under Chapter 744 of the Florida statutes and the rights of a person under the Baker Act, the Baker Act prevails according to the appellate courts.
Rarely will a long-term care facility resident with the capacity to make well-reasoned, willful, and knowing decisions about his/her medical or mental health treatment require transfer to a Baker Act receiving facility for examination and treatment. An independent professional must evaluate the resident's capacity to provide express and informed consent prior to transfer to a receiving facility. The only other alternative is to have an involuntary examination initiated by the physician or other authorized mental health professional associated with the long-term care facility.
Another group that can assist with this voluntary admission for long-term care residents is a mobile crisis response service. This is a non-residential crisis service that's attached to a public receiving facility and available 24 hours a day, 7 days a week, through which immediate intensive assessment and intervention, including that screening for admission into a receiving facility, takes place for the purpose of identifying appropriate treatment services. The Baker Act encourages the voluntary admission of individuals for psychiatric care, but only when they're able to fully understand the decision and its consequences and are also able to fully exercise their rights for themselves. When this is not possible due to the severity of the person's condition, then the law requires that that person be extended the due process rights assured under the involuntary provisions of the law. If a competent adult or the guardian of a minor refuses to consent to mental health treatment, the person shall not be eligible for admission on a voluntary status, but may be held up to 24 hours after a request for discharge from a receiving facility, and a petition can be filed for involuntary placement instead. A person may be taken into a receiving facility for involuntary examination if there is reason to believe that he or she is mentally ill as defined in the law. Because of their mental illness, 1, they've refused a voluntary examination after conscientious explanation and disclosure of the purpose of that examination, or the person is unable to determine whether they need the examination, and 2, without care or treatment, the person is likely to suffer from neglect or refuses to care for themselves. Such neglect or refusal poses a real and present threat of substantial harm to their well-being, and it's not apparent that such harm can be avoided through the help of willing family members or friends or the provision of other services. Or there is substantial likelihood that without care or treatment, the person will cause bodily harm to themselves or others in the near future, as evidenced by their recent behavior. An involuntary examination may be initiated by one of 3 ways: a circuit court judge, a law enforcement officer, or an authorized mental health professional. Definitions of mental health professionals are specified in the Baker Act. One cannot rely on the definitions in the licensing acts. The definitions are as listed on this slide. Some of the definitions of these professionals in the Baker Act are not consistent with those in licensing statute. When general laws, like the licensing laws, are in conflict with a specific law, like the Baker Act, then the specific law takes precedence over the general law. In other words, definitions presented here are the ones to use for mental health professionals authorized to admit patients on an involuntary status. A parent or guardian cannot initiate or prevent an involuntary examination of a minor. Involuntary examinations can only be initiated by ex parte order of the court, law enforcement, or certificate from the mental health professional. A receiving facility is any public or private facility that's designated by the department to receive and hold involuntary patients under emergency conditions. They're to provide psychiatric evaluations and short-term psychiatric treatment. A jail is not a receiving facility. If the minor requires something different than the psychiatric exam or short-term psychiatric treatment, then they should not be sent to a receiving facility. Crisis Stabilization Units, or CSUs, are receiving facilities that receive public funding. They may screen, assess, and admit persons on either voluntary or involuntary status. In addition to 24-hour observation, clients receive all necessary treatment, including prescribed medications. CSUs can charge fees on a sliding scale, but must provide services regardless of a client's ability to pay. Florida established Crisis Stabilization Units for Children and Adolescents, or CCSUs, through the community mental health centers. CCSUs cannot exceed 20 beds, and the purpose of a crisis stabilization unit for children is to stabilize the minor and redirect them to the least restrictive, most appropriate community setting consistent with their needs. A person can be taken to a Baker Act receiving facility for involuntary examination if there is reason to believe that they have a mental illness as defined by the law, and because of this mental illness, that individual has refused examination or is unable to determine whether examination is necessary, and without care or treatment, that resident is likely to suffer from neglect or refuse to care for themselves. Such neglect or refusal poses a real and a present threat of substantial harm to that individual's well-being, and it is not apparent that such harm may be avoided through the help of willing family members or friends or staff, or the provision of other services. There is a substantial likelihood that without care or treatment that the person will cause serious bodily harm to themselves or others in the near future, as evidenced by the recent behavior. A law enforcement officer is required to take a person who appears to meet the criteria for involuntary examination into custody and deliver that person or have them delivered to the nearest receiving facility for examination. There is a duty for the officer to initiate the involuntary examination if the officer believes the criteria are being met. The officer must take the person into custody for that involuntary examination. There is no expectation for law enforcement officers to be diagnosticians. They are expected to know what a well-trained officer should know, and no more or no less. The Baker Act does not require a law enforcement officer to personally observe the behaviors leading to an involuntary examination. It simply states that the officer must describe the circumstances under which the person was taken into custody. If the officer has a credible witness or witnesses, then the officer can document, quote, information offered by others, unquote, and transport the person to the nearest receiving facility. A law enforcement officer is required by law to take the person named in the ex parte order or certificate of a mental health professional into custody and deliver them to the nearest receiving facility for involuntary examination. If that individual is already at a hospital, in which case then the federal EMTALA law places responsibility to arrange safe and appropriate transfer of that person on the sending hospital. The officer is required to execute a written transportation report detailing the circumstances under which the person was taken into custody. The law enforcement officer's transportation form and the mental health professional report and certificate must be made a part of the individual's clinical record. The law enforcement officer must complete the form entitled Transportation to Receiving Facility, CF-MH3100, describing the circumstances under which the person was taken into custody. The Baker Act forbids the removal of a person from any program or residential placement licensed under Chapter 400 or 429 of the Florida statutes, and transportation to a receiving facility for involuntary examination unless a professional certificate or a court's ex parte order or a law enforcement officer's report is first prepared. If the client's condition is such that preparation of a law enforcement officer's report is not practical before the removal, then the report must be completed as soon as possible after the removal, but in any case before the person is transported to a Baker Act receiving facility. If the sending facility fails to properly initiate an involuntary examination, the Baker Act receiving facility must report failure to the Agency for Healthcare Administration, AHCA, by certified mail on the next working day. While it is true that law enforcement officers are required to transport minors to the nearest receiving facility unless there is a transportation exception plan in place, hospitals governed by EMTALA law must accept any person brought to the emergency room and screen and stabilize them before releasing or transferring that person. A county-wide transportation exception plan allows law enforcement officers to bypass the nearest receiving facility in favor of a facility with pediatric psychiatric beds. This map of the state indicates the transportation exception plans. Such plans, when approved by a board of county commissioners and the Secretary of DCF, permit more efficient, effective, and humane methods of transporting persons in psychiatric crisis to designated receiving facilities that are most appropriate to meet special needs. Another exception to law enforcement being the provider of transportation for residents who need to go to a receiving facility would be when a staff of mental health overlay programs or crisis response services have chosen to provide the transportation after doing an assessment at the facility.
911, where's your emergency?
My son, Bill, is outside the house. He's yelling at a pedestrian and running toward him. He has a history of schizophrenia, and he's not on his medication right now. I need someone sent immediately.
All right, ma'am, is he near you? Is he in the house, or is he...
No, he's outside.
All right, does he have any weapons? Can he hurt himself or you?
No, he's not carrying a weapon, and he's not normally violent.
Stop watching me. I see you watching me with your look, and you're watching and you're reporting on me, and I can't have that. I just want to be left alone, so leave me alone. Get out of here. Go. Get out of here. Stop watching me. I said stop watching me. Stop watching me, please. I just want to be left alone. Just leave me alone. Get out of here.
I'm Sergeant Garrity.
Who called you? What are you doing here? I'm not doing anything.
Can we talk? Someone called and said you appeared to be upset.
You'd be upset too if you were monitored like me. I just want to be left alone.
What's your name? What can I call you?
I'm Bill.
Bill, are you feeling okay today?
I'm fine. Everyone just needs to leave me alone. I don't need people walking by and reporting on me.
Bill, we're here to help you. Why don't you have a seat on the stairs over there and talk to me? Let me see what I can do.
Just leave me alone.
Someone called and said that you appeared to be upset and that you were yelling at people. Is there anyone that might want to hurt you or is angry with you?
Just go away. I don't need more people watching me. Why is it always me?
Bill, I want to help you. No one's going to hurt you with us here. My partner, Officer Baker, is right over there and will watch out for us, okay? Why don't you tell me what's going on?
My family is watching me. Yeah. They're worried that I'm going to do something.
Okay, like what?
I don't know. I never do. I ask them to stop, but they won't.
Bill, I'd like to talk to you a bit more, but this is not the most private of areas. Would it be okay with you to come back to my headquarters with me? It's safe there and we can talk privately.
Okay. Can you drive me back afterwards?
Should not be a problem. How about you sit in my car?
Okay.
Bill, you don't have anything on you that could hurt me, do you?
No.
I'm just going to check for our protection, okay?
Okay.
Sergeant Garrity, the contact officer, and Bill go to police headquarters. Meanwhile, the backup officer knocks on the door of Bill's house and talks to Bill's mother. She hands the officer an index card with key information about Bill's mental health issues. The police department's dispatch is notified that Sergeant Garrity and Bill are coming to the station. The police dispatch also calls the psychiatric screening program. 15 minutes later, 262 Help arrives at police headquarters to conduct Bill's evaluation.
Hi, Sergeant Garrity. I'm Amy from 262 Help, a service of Care Plus New Jersey. I'm here to evaluate Bill.
Hi, Amy. Bill's in our interview room. He's calmed down, but he's still a bit paranoid that he's being watched. I'll stay by your side as you're asking questions.
Okay, great.
Come on, let's go inside.
Thank you. Hi, Bill. I'm Amy from Bergen County Psychiatric Emergency Screening Program. Sergeant Garrity was concerned about you and asked me to come speak with you today. Can you tell me a little bit about what happened?
I'm not going to speak to you. You're one of them.
Bill, just answer the lady's questions. Remember, we told you you're going to have to answer just a few questions.
I know that you're recording this whole conversation. I'm not going to talk to you. You're just after my knowledge. Everyone is.
Well, Bill, I can tell you that we're not recording this conversation, and I'm really here because I'm concerned and I want to make sure that you're okay.
No, I'm not going to talk to you at all, and just going to not share anything.
Here, the 262 Help screener's role is to conduct as much of the evaluation as possible, depending on how lucid and alert the individual is. In this situation, the screener attempts to engage Bill, but is unsuccessful. The screener excuses herself from the room to call Bill's mother for more information.
Hello? Hi, is Nancy available?
This is she.
Hi, Nancy. My name is Amy. I'm a certified mental health screener with 262 Help, Bergen County Psychiatric Emergency Screening Program.
Hi, Amy.
I was advised your son's experiencing a mental health crisis today and was asked to come out and evaluate him at police headquarters. Can you please tell me a little bit about what happened this morning?
The screener will speak with the individual in crisis and others involved in the case. Using this information, the screener will determine the best course of action. Action steps can include referring the individual to resources or sending the individual in crisis to the designated screening center for further evaluation and treatment. In this case, the assessment calls for Bill to be transported to the designated screening center at Bergen Regional Medical Center's emergency room. Once at the hospital, Bill will be seen by a medical doctor to evaluate his physical condition. After he is medically cleared, he will be evaluated by a psychiatrist. Throughout the intervention, the focus is on the person in crisis, but it is important to remember the effects the crisis will have on family members and loved ones.
This concludes the coursework for Module 1. Do you know the various ages and stages of child development from a psychosocial perspective? How about the general criteria for voluntary admission, involuntary examination, and transportation under the Baker Act? Can you describe express and informed consent and identify special protections for minors under the Baker Act? What is CSU or CCSU? If you are comfortable answering these questions, then you're ready to move on to the knowledge review for Module 1. If not, then go back and review this module again until you're comfortable with this content, and then go ahead and take the knowledge review. You are now ready to complete the knowledge review. Go back to the M1 tab and click open the Module 1 Knowledge Review. After completing the knowledge review, you may decide that you need additional study of this information. If so, return to the beginning of the module. If you correctly answer 8 out of 10 questions, or 80%, on the knowledge review, then you may go on to Module 2, the M2 tab.